Good evening, and it's great to have you with us here on a Thursday night. We do begin tonight with the landmark Supreme Court ruling striking down affirmative action as we know it in college admissions, overturning a key tool used for more than 40 years to make campuses more diverse in this country. Two schools at the center of this decision, Harvard, America's oldest private university, and the University of North Carolina, the oldest public one. The 6-3 decision with the conservative majority standing together, the liberal minority united in dissent. Chief Justice John Roberts, writing for the majority, saying the two schools' admissions policies, quote, involve racial stereotyping in a way that violates the Constitution. Justice Clarence Thomas, acknowledging he benefited from affirmative action, siding with the majority, saying race-conscious practices, quote, fly in the face of our colorblind Constitution. Justice Sonia Sotomayor also crediting affirmative action with her success in life, saying the court's decision, quote, rolls back decades of precedent and momentous progress in this country. And today, the moment at the White House when the president was asked, is this a rogue court? He paused, the silence in the Roosevelt room, and then he said, this is not a normal court. ABC's Terry Moran leading us off tonight from the Supreme Court.
Tonight, the end of an era in American law and American life. The Supreme Court in a 6-3 decision ending affirmative action in higher education as we know it. Chief Justice John Roberts, joined by the court's 5 other conservatives, declaring that the admissions policies at Harvard and the University of North Carolina violate the Constitution's guarantee of equal protection of the laws. Roberts writing that the school's affirmative action policies unavoidably employ race in a negative manner and involve racial stereotyping. Under the Constitution, Roberts added, eliminating racial discrimination means eliminating all of it. But the Chief Justice adding that some consideration of the racial background of an applicant is still lawful in applications essays, for example. Roberts writing, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, Roberts wrote. Still, he warned, the student must be treated based on his or her experiences as an individual, not on the basis of race. In a searing dissent, Justice Sonia Sotomayor, joined by the court's 2 other liberals, declaring, the devastating impact of this decision cannot be overstated. Ignoring racial inequality will not make it disappear. Sotomayor, who has written about how affirmative action programs helped her rise from the Bronx Housing Project to Princeton University and Yale Law School to the Supreme Court, adding, equal educational opportunity is a prerequisite to achieving racial equality in our nation. Justice Clarence Thomas, who also acknowledges benefiting from affirmative action himself, but who has spent more than 30 years on the court trying to end it, striking a deeply personal note in his concurring opinion. While I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles, that all men are created equal, are equal citizens, and must be treated equally under the law. The Constitution, Thomas declared, is colorblind. Justice Ketanji Brown Jackson responding in a forceful dissent. With let them eat cake obliviousness, today the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. The court's opinion exempts the U.S. military academies from today's ban on affirmative action in admissions, Chief Justice Roberts saying they present potentially distinct interests. That drew sharp sarcasm from Justice Jackson, who retorted, racial diversity in higher education is only worth potentially preserving insofar as it might be needed to prepare Black Americans and other underrepresented minorities for success in the bunker, not the boardroom. Over the course of 45 years since the court first approved the use of race as one factor in college admissions, affirmative action has reshaped life and learning on American campuses. Today, students were reckoning with what the Supreme Court has done. Alex Shea, who will go to Brown University this fall, telling us,
it does make me feel a little bit uncomfortable knowing that in that admissions office, when they were deciding whether they were going to accept me, reject me, that they might have been considering my race, because I think that that's not something that I can control or that anyone can control. And I think that it's unfair to judge someone based on that.
And Duke University student Bumi Omasware.
My identity has to be my race, the struggles that I've gone through, the trauma I've gone through as an African-American woman in the United States. If I were applying to college today, I would have to write about those traumas in my Common Up essay. I would have to write about those traumas and those very hard experiences for admissions officers to accept the overwhelming truth that we all know, which is that it is hard to be a Black person in America. And I don't think that's fair.
Today's landmark ruling will have consequences far beyond higher education. And while it does not directly apply to employers, which are covered by a different statute, its reasoning is a roadmap for challenges to diversity, equity, and inclusion programs at so many corporations. And conservative activists, well, they are already targeting hiring and promotion and internship programs at major employers like Morgan Stanley, McDonald's, and Starbucks. David?
The ripple effect could be wide here. Terry Moran leading us off tonight. Terry, thank you.